Good afternoon. It is my pleasure to introduce our 2013 Centennial speaker, Erwin Chemerinsky. He's the founding dean of the University of California, Irvine School of Law, and the distinguished professor of law, Raymond Pike, professor of First Amendment law with a joint appointment in political science. Before becoming dean at UC Irvine, Dean Chemerinsky taught at Duke Law School for 4 years, and before that at the University of Southern California for 21 years. And that's where I first met Dean Chemerinsky. He has also taught at UCLA and at DePaul, our neighbor up the street. Dean Chemerinsky is from Chicago originally, received his BA from Northwestern and his JD from Harvard. He's an expert in constitutional law, federal practice, civil rights and civil liberties, and appellate litigation. He's the author of 7 books. The most recently published is The Conservative Assault on the Constitution. He's also the author of nearly 200 law review articles and has argued cases before the US Supreme Court, and in fact has an argument this December. And he's also argued cases before many federal courts of appeals. Some of you may remember the state criminal trial of O.J. Simpson, which captivated the nation back in 1995. Dean Chemerinsky provided legal commentary for that trial. He's also served on several notable commissions, such as the LAPD panel, which reviewed the Rampart scandal in Los Angeles, and he's a frequent contributor to legal commentary and giving legal opinions. And you might be asking at this point, how does Dean Chemerinsky manage to do all this? Well, if you ask him, as I did, he says that he doesn't need much sleep, just a few hours a night. I'm not sure that strategy will work for the rest of us, but one thing that I can tell you from personal experience is that no matter how busy Dean Chemerinsky is, and you can see from what I've described, he is extraordinarily busy, he's also extraordinarily generous with his time. Whether you're a student of his or a young faculty member just starting out, as I was when I first met Dean Chemerinsky, he will always make time for you, whether it's to answer a question a student has about a case or a junior faculty member has about teaching. Dean Chemerinsky is available. He and his family opened up their house on holidays and made those of us who were far away from our families feel welcome and feel like we were part of his family. So it is my great honor to be able to introduce Dean Chemerinsky, who is someone who is a recognized scholar, but even more important, to me at least, a great teacher, a great mentor, and a great friend. And he's willing to give generously of his time, as he is today at Chicago Kent. So he will speak on the topic of, has the Supreme Court lost faith in the courts? Which seems particularly fitting today, being the first Monday in October, and the Supreme Court has begun a new term. He'll take questions afterward. So please help me to welcome Dean Chemerinsky.
Sweet, you're so kind, thank you. That was so incredibly sweet. Thank you so much. It's really an honor and a pleasure to be with you today. As Professor Martin mentioned, it is fortuitous that I'm speaking to you about the Supreme Court on the first Monday in October. At 10 o'clock Eastern time this morning, the term began with the Supreme Court hearing a case called Madigan versus Levine. As I describe the current Supreme Court to you, I would say that to understand it, you should most of all think of it as the Anthony Kennedy Court. I know out of tradition and deference to the chief, we refer to it as the Roberts Court, but at least from the perspective of the lawyers who stand before the justice and write briefs to them, this really is the Kennedy Court. Last term, Justice Kennedy was in the majority more than any other justice, 93% of the time. In fact, for each of the 8 years that John Roberts has been Chief Justice, Anthony Kennedy is in the majority more than any other justice. But it's really the 5-4 decisions that show you the importance of Anthony Kennedy. Those, by definition, are the most controversial and usually the most important. Last term, Justice Kennedy was in the majority by far more than any other justice in the 5-4 decisions. This, too, has been true for each of the 8 years that John Roberts has been chief. Last year, the Supreme Court decided 73 cases after briefing and oral argument. In 23 of them, or about a third of the docket, the matter was resolved by a 5-4 vote. Justice Kennedy was the majority in 20 of those 23 5-4 cases. The runner-up was Justice Scalia, and he was the majority in only 13 of the 23 5-4 decisions. I think then you can get an overall sense of the ideology of the Roberts Court by focusing on the 5-4 decisions that are split along traditional ideological lines and seeing where Justice Kennedy lines up. Last term, there were 16 5-4 cases. On the one side, you had Roberts, Scalia, Kennedy, Thomas, and Alito, and on the other, Ginsburg, Breyer, Sotomayor, and Kagan. Kennedy was with the conservatives in 10 and with the liberals in 6. I've added this up for the 8 years that John Roberts has been Chief Justice. When the court is ideologically divided 5-4, Kennedy is with the conservatives about 70% of the time, and with the liberals about 30% of the time. If nothing else, this is relevant, as I said, for the lawyers. As Mr. Martin mentioned, I'm re-arguing a First Amendment case before the Supreme Court the first week of December, working on my brief now, which is due October 21st. I had the pleasure of talking with some students this morning about the brief. I give away no secrets when I tell you that my brief is a shameless attempt to pander to Justice Kennedy. If I could put Anthony Kennedy's picture on the front of my brief, I would do so. What I want to talk with you about this afternoon is one aspect of the Roberts Court's jurisprudence. I think it's a particularly important aspect, and it's one that's received relatively little media attention. And that's the way in which the Supreme Court is closing the courthouse doors. I want to talk about the theme of access to justice. What I want to suggest to you is that in a number of different areas, what the Supreme Court has done is keep people with constitutional and statutory claims from ever having their day in court. Let me go through some examples for you and then try to talk about why and what it means for society, for the law, for us as lawyers, law professors, and law students. The first area I want to talk about is how the Supreme Court is closing the courthouse doors to those who want to sue businesses. It's certainly been suggested by many that the current court is the most pro-business Supreme Court that there's been since the mid-1930s. You might have seen an article by Adam Liptak in the New York Times last spring, filled with charts and graphs demonstrating that the current court is the most pro-business court that we've had since the mid-1930s. It was actually based on a longer article by a couple of professors and a federal court of appeals judge that again tried to use statistical methods for confirming what's the intuition of many. This is a very pro-business court. But let me make it concrete with some illustrations. One way in which this is a pro-business court, and the court is closing off access to the judiciary, is by its strongly favoring arbitration over adjudication. You can here, throughout, use examples from recent terms of the court. In 2011, the court decided a case called AT&T Mobility versus Concepcion. AT&T was advertising free cell phones to those who would sign up for its service. The Concepcions, a married couple, went to get their cell phones. They, like all of us, had to sign an agreement for their cell phone service. They, my guess is like most of us, didn't read the agreement they were signing. They were surprised when they got their first monthly statement that they were each charged $30.22 in sales tax. They thought that since AT&T was promising free cell phones, AT&T should have to absorb the cost. They wanted to join in a class action suit against AT&T for fraud. But in the agreement between AT&T and the Concepcions, for that matter, the agreement between AT&T and all of its customers, there was a clause that said that any dispute had to go to arbitration. It couldn't go to court. AT&T invoked that clause to keep the Concepcions from suing in court. There's The federal statute adopted in 1925, the Federal Arbitration Act, which says for contracts in interstate commerce, arbitration clauses shall be enforced unless they're revocable under state law. The California Supreme Court had ruled in the Discover Bank case that arbitration clauses in routine consumer contracts are not enforceable in California. The California Supreme Court referred to them as contracts of adhesion. The Ninth Circuit said, since this is a clause not enforceable under California law, the Concepcions don't have to go to arbitration. The Supreme Court, in a 5-4 decision, reversed. Justice Scalia wrote for the court, joined by Chief Justice Roberts, Justice Kennedy, Justice Thomas, and Justice Alito. Justice Scalia began by extolling the virtues of arbitration over court adjudication. Justice Scalia talked about the ill effects of class actions on businesses. He said class actions force business to settle even non-meritorious suits. Justice Scalia's words, and I quote them, that there's an interim effect on business, force them to settle class actions that have no basis. And thus the court said that the Concepciones had to go to arbitration, they couldn't sue, and they couldn't be part of a class action remedy. Justice Breyer wrote for the dissenters. He said, the alternative here isn't hundreds of thousands or millions of separate claims against AT&T. The alternative is no claims against AT&T because no one's going to sue, go to arbitration for $30.22. He said that the importance of class actions, situations like this, where a large number of people each lose a small amount of money. The Supreme Court followed this decision with one in June of 2013, American Express versus Italian Colors restaurant. Italian Colors is a small restaurant. It takes American Express cards. It was upset, though, that it has to pay 30% more on each transaction with an American Express card compared to each transaction using a different credit card. It believed that American Express was leveraging its market share to impose this greater cost in a manner that violated federal antitrust laws. So it wanted to bring a class action against American Express for violating the Sherman and Clayton federal antitrust laws. But Italian Colors had an agreement with American Express, and in it was a clause that said that if any dispute, it would have to go to arbitration, and it couldn't be class-wide arbitration. Italian Colors responded by saying it costs hundreds of thousands, if not millions of dollars, to successfully bring an antitrust claim. The maximum recovery for a federal antitrust claim, including treble damages, is $39,000. So Italian Colors said, no one's going to spend hundreds of thousands, let alone millions of dollars, to recover $39,000. They should be able to go forward with a class action suit. The Supreme Court, 5-4, ruled in favor of American Express. Again, Justice Scalia wrote for the court, joined by Roberts, Kennedy, Thomas, and Alito. Justice Scalia, writing for the court here, said that the Federal Arbitration Act requires arbitration contract where there are clauses that call for it. There's no exception for a circumstance like this. Here, Justice Kagan wrote for the dissent. And Justice Kagan said, let's be clear about what this means. A company can enter an agreement that violates federal antitrust law and then completely immunize itself from any liability just by having a clause that prohibits class action suits. Justice Kagan said, the majority's response to this is, quote, too darn bad. You look at these cases and several others that I could mention from recent years where the Supreme Court has strongly favored arbitration over court adjudication. It certainly affects us as lawyers, but it also affects all of us as employees, as consumers, as patients. Arbitration clauses are increasingly ubiquitous in all of these contexts. Not long ago, I went to see a new eye doctor for the first time, and the receptionist gave me a big stack of papers to fill out. In the middle was a form that I was asked to sign that if I had any claim against the eye doctor, I would have to go to arbitration. I couldn't sue in court. I asked the receptionist if the doctor would still see me if I didn't sign the paper. She said she didn't know. Nobody had ever asked her that question before. But I've now heard of many physicians who won't treat patients unless they sign arbitration agreements. Around the same time, I bought a new Dell computer. As you know, in order to use a computer or an iPad for the first time, you have to click that you've read the terms and agree to them. I usually just click agree and use the machine. If you've used an iPad and you've looked, there's 46 single-spaced pages of terms you're supposed to read before you click agree. Well, when I bought my new Dell computer, I decided to actually look at the terms. And sure enough, paragraph 8 said that if any claim against Dell arising out of the computer, I would have to go to arbitration. I couldn't sue them in court. I wrote Dell a letter back saying I did not agree to paragraph 8, and by opening the envelope of my letter, they agreed that I could sue them in court. Dell did not write back, but the computer still works. Let me give you another example of the Supreme Court closing the courthouse doors to those who want to sue business. Again, let me be an example that affects all of us. The Supreme Court, over the last few years, has made it impossible to sue generic drug companies, no matter how horrible the injuries inflicted by their products. Now, here I want to start the story in 2009 with a case called Wyeth versus Levine. You might remember Diane Levine was a musician in Vermont. She was suffering from a severe migraine, and she went to a hospital emergency room for treatment. She was given Demerol to counteract the pain that she was suffering, and Phenergan to counteract her nausea. Phenergan is known as a highly corrosive substance, and it's supposed to be given diluted through a saline solution in an IV drip. It was given to her directly as a shot into her vein. Because of the corrosive effects of Phenergan, she felt gangrene in her arm, and her arm had to be amputated. She sued the drug company, Wyeth. She sued them for failure to adequately warn patients. Wyeth's defense was to say its warning label had been approved by the Food and Drug Administration, so a claim for failure to warn was preempted by federal law. The Supreme Court 6-3 ruled in favor of Diane Levine. Justice Stevens wrote the opinion for the court. He said, drug companies can always engage in more speech. They take out ads all the time in the media. Those ads could be to warn patients and physicians of side effects. Drug companies can send out Dear Doctor letters to physicians to warn them of side effects. Drug companies can ask the FDA to change their warning label. The court said allowing tort liability for failure to warn would further the underlying regulatory goal of safe drugs and better informed patients. 2 years later, the court decided a case called Pliva versus Mincing. The issue here was whether the maker of a generic drug could be sued on a failure to warn theory. This case involves a drug that's often prescribed with those with diabetes to speed digestion. It's now known that a significant percentage of prolonged users, 29%, will suffer horrible, irreversible neurological side effects. 2 women in different parts of the country who used the drug and sued the side effect, sued the drug company on a failure to warn theory. The Supreme Court ruled, though, 5-4, that makers of generic drugs cannot be sued on a failure to warn theory. Justice Thomas wrote for the court, joined by Chief Justice Roberts, Justice Scalia, Justice Kennedy, and Justice Alito. Justice Thomas said, the Hatch-Waxman amendments to the Food and Drug Act say that a generic drug can be sold if it's chemically the same as the brand name drug and if it has the warning label that's approved for the brand name drug. He said the generic drug has to have the same warning label that's approved for the brand name drug. It can't change the warning label, so it can't be sued on a failure to warn theory. He concluded by saying, I know it's no consolation to these 2 women that if they'd taken the brand name version of the drug, they could sue, but because they took the generic version, they can't. He said, direct that to Congress, not the court. Justice Sotomayor wrote for the 4 dissenters. It was a vehement dissent. And she emphasized, it makes no sense for the same chemical compound. If a person takes the brand name drug, they can sue for the injuries, but if they take the generic drug, they can't. She said the whole point of the Hatch-Waxman Amendment was to protect consumers. Justice Sotomayor said, we just said 2 years ago, Drug companies can always engage in more speech. They can take out ads to warn patients and physicians that more speech furthers the regulatory goal. Well, let me conclude this part of the talk by discussing a case from June of 2013, Mutual Pharmaceuticals versus Bartlett. Mutual Pharmaceuticals versus Bartlett involves a woman in New Hampshire who was given a prescription for the pain reliever Soldenac. Her prescription was filled with a generic drug. She took it and she suffered a horrific, rare, though known side effect. 2/3 of the skin on her body burned, blistered, and decayed. She spent months in a medically induced coma. She's now permanently disfigured and blind. She sued the maker of the generic drug on a design defect theory. The jury in New Hampshire ruled in her favor. The New Hampshire Supreme Court affirmed. The United States Supreme Court reversed 5-4. Here, Justice Alito writing, joined by Roberts, Scalia, Kennedy, and Thomas. Justice Alito said, under the Hatch-Waxman Amendment, a generic drug can be sold so long as it's chemically the same as the brand name drug and so long as it has the warning label that's approved for the brand name drug. He said there's therefore only two possible ways for a generic drug company to avoid liability. One would be to change the chemical compound to make the side effect less likely. He said the generic drug maker can't do that. The other would be to strengthen the warning label. And we said 2 years ago in Pliva versus Mincing, they can't do that. Can't be held liable for failure to change the warning label. He said, therefore, any liability for generic drug companies is preempted. Here, Justices Breyer and Sotomayor both wrote dissenting opinions, joined by Justices Ginsburg and Kagan. They said the majority sees only two choices, but there's another choice. Don't sell the drug. And if you do sell the drug, then pay damages for what's caused. But now the law is that makers of generic drugs can't be sued. Not in federal court, not in state court. Not for failure to warn, not for design defects. This matters so much. According to the FDA, about 80% of all prescriptions in the United States are filled with generic drugs. Where there's a generic equivalent to the brand name drug, over 90% of the time the prescription is filled with the generic. All who take generic drugs simply have the courthouse doors closed should they want to sue for injuries, even terrible injuries. The second theme that I would identify for you is that the Supreme Court has closed the courthouse doors to those who want to sue the government. There are many ways in which the Supreme Court has done this over recent years. Again, let me just give you a few examples. One is the way in which the Supreme Court has restricted those who have standing to sue the government. The Supreme Court in recent years has made it much more difficult for plaintiffs to have standing to sue in federal court, a requirement for any federal court litigation. Let me again pick as an example something from last term, a case called Clapper versus Amnesty International. In 2008, Congress amended the Foreign Intelligence Surveillance Act to make it much easier for the National Security Agency to intercept communications between those in the United States and those in specified foreign countries. When the NSA does this, it can literally listen to the conversations, read the email. The day this new law went into effect, a lawsuit was brought challenging it. Plaintiffs included lawyers. They said they regularly represent clients in these countries where the communications are being intercepted. They said they're required by the ethics of our profession to protect the attorney-client privilege. Therefore, the only way they can communicate with their clients and be consistent with professional norms is to travel to these countries. The plaintiffs included business people who said they regularly make deals with people in these countries, and they're chilled from communications by fear the communications will be intercepted. The plaintiffs included journalists who said they want to talk to sources in these countries. The Supreme Court ruled this past spring 5-4 that the case had to be dismissed for lack of standing. Justice Alito wrote the opinion for the court here, joined by Roberts, Scalia, Kennedy, and Thomas. Justice Alito said, in order for a plaintiff to standing to sue, the individual has to show that he or she has been or imminently will be injured. Justice Alito said none of the plaintiffs can show that their conversations were intercepted by the NSA or likely to be intercepted by NSA in the future. The NSA doesn't tell people when it intercepts their communications. The court thus said there's not an injury sufficient for standing. Justice Breyer wrote for the four dissenters. He said, know what this means, that even if this law is unconstitutional, even egregiously unconstitutional, no one will ever have standing to be able to challenge it, because no one will ever be able to show that his or her conversations were intercepted by the National Security Agency. The dissent would have said the claim of the chilling of speech is an injury sufficient for standing. As I discussed this case, I recently saw a picture of President Obama talking to a young boy. And the caption under it had the boy saying, "Mr. President, my father says you're listening in to our conversations." The president's response was, "Son, he's not your father." Another way in which the Supreme Court has closed the courthouse doors to those who want to sue the government is a tremendous expansion of sovereign immunity. The Supreme Court has made it much more difficult to sue state governments, even when they violate federal laws, even when they're sued in state courts. The example that I want to pick is how the Supreme Court has made it much harder to sue local governments as well, even when there are egregious constitutional violations. Here I'll pick a case from just a couple of years ago, Coleman versus Thompson. John Thompson spent 18 and a half years in prison for murders that he did not commit. When he was tried for these murders, an assistant district attorney was given blood evidence that was said to link to Thompson and the crime for which he was being tried. The assistant district attorney is required by the law to turn the blood evidence over to the defense so it can be tested. Brady versus Maryland in 1963 said that prosecutors must turn over to defense lawyers any potentially exculpatory evidence. The rules of ethics in every state require this as well. The assistant district attorney didn't turn over the blood evidence. Instead, he hid it. Many years later, when he was literally on his deathbed, dying of cancer, he told another assistant district attorney what he had done. That assistant district attorney told no one. Literally just weeks before Thompson's scheduled execution, through a series of coincidences, his lawyers learned of the blood evidence. And the blood swatch was still in the archives. It was tested. Not only didn't it match Thompson's DNA, it didn't even match his blood type. Thompson's conviction was overturned, he was retried, he was acquitted. So he sued the local government for being responsible for violation of his constitutional rights. The jury ruled in his favor, gave a large damage judgment. The United States Court of Appeals for the Fifth Circuit affirmed. The Supreme Court, though, reversed in a 5-4 decision. Justice Thomas writing, joined by Robert Scalia, Kennedy, and Alito. Justice Thomas writing for the court said, this is a suit against a local government. It's the government that prosecuted John Thompson. The court said, you can only hold a local government liable if you can prove that its own policy or custom violated the Constitution. Justice Thomas said, well, this is just one instance. One instance isn't enough to prove a policy or custom. Justice Ginsburg wrote a forceful dissent. She said, there isn't just one incident here. She said, 5 different assistant district attorneys in New Orleans over an 18-year period knew of this blood evidence, and not one spoke out. She said, this isn't the only Brady violation in this case. Turns out that there was an eyewitness to the murders. The eyewitness described the assailant as having short hair. Thompson had a large afro at the time of the murders. That fact was never turned over or revealed to the defense counsel. Justice Ginsburg said, there's evidence of a long pattern of Brady violations in New Orleans. Why isn't this enough for liability? Thompson was left without any recovery. Literally, the courthouse door was slammed on him. The third example that I want to talk about of closing the courthouse doors is how the Supreme Court has closed the courthouse doors to plaintiffs in civil litigation. And the case I want to focus on here is Ashcroft versus Iqbal from 2009. If you ask me, from a practical perspective, what's the most important case to come down during the 8 years that John Roberts been Chief Justice, I would point to Ashcroft versus Iqbal. In fact, of all the cases the Supreme Court has decided since John Roberts became chief, Ashcroft versus Iqbal is the most frequently cited. In fact, of all the cases decided by the Supreme Court in its history, Ashcroft versus Iqbal is now among the 5 most frequently cited by the lower courts, and it's a decision that's just a little over 4 years old. In the 1930s, the Federal Rules of Civil Procedure ushered in what was thought to be a system of notice pleading. I've taught civil procedure many times, and I always instructed my students that the embodiment of notice pleading was a Supreme Court decision from the mid-1950s, Conley versus Gibson. Conley versus Gibson says that a complaint should be dismissed for failure to state a claim only if there's no set of facts upon which relief can be had. The philosophy of the federal rules was to make it easy for plaintiffs to bring a suit in federal court, to let them have discovery, and then use the summary judgment stage to filter non-meritorious claims. In 2007, in a case called Bell Atlantic versus Twombly, the Supreme Court surprised everyone by suggesting a change in the pleading standard. Bell Atlantic versus Twombly was an antitrust case. It was in the Sherman antitrust law. And the Supreme Court 7-2 ruled that the case had to be dismissed for failing to state a claim under Rule 12b-6 of the Federal Rules of Civil Procedure. Justice Souter wrote for the court. Only Justices Stevens and Ginsburg dissented. Justice Souter's opinion was very much about pleading in antitrust litigation, and it was reasonable to read the case just as being about that. In fact, in November of 2008, there was a national conference of Federal Court of Appeals judges. And for each topic, they had a Supreme Court justice and 2 law professors as the panel. Justice Breyer was there to talk about civil litigation. I had the pleasure and privilege of being there, and I was surprised to hear Federal Court of Appeals judges in the audience, with frustration and even anger in their voice, saying to Justice Breyer, "What's the standard of pleading after Bell Atlantic versus Twombly?" Finally, Justice Breyer responded, with frustration and even anger in his voice, "Bell Atlantic versus Twombly is just about pleading in antitrust cases." It was a plausible reading. However, 6 months later, we learned that Justice Breyer was wrong. The court decided Ashcroft versus Iqbal. If you haven't studied it yet, I'm sure you will in civil procedure. Iqbal was a man of Pakistani descent. He was detained in New York after September 11th. Upon his release, he brought a lawsuit against, among others, the Attorney General and the head of the FBI, said that his detention violated his constitutional rights. The Attorney General, then John Ashcroft, moved to dismiss for failure to state a claim. The Supreme Court held 5-4 that Iqbal's complaint should be dismissed. Justice Kennedy wrote for the court, joined by Chief Justice Roberts, Justice Scalia, Justice Thomas, and Justice Alito. Justice Kennedy said the standard of pleading in federal courts is now one of plausibility. The plaintiff must allege enough facts that it's plausible that the plaintiff can recover. Justice Kennedy said that plausibility is to be determined by context and common sense. Now, I've always taught my students in civil procedure that when a federal court assesses a motion to dismiss, it's supposed to accept all the allegations of the complaint is true. Justice Kennedy said no longer is that so. He said that a federal court should go through a complaint and exclude all the conclusory allegations of fact, exclude all the statements of law, and decide based on what remains whether it's plausible that the plaintiff can recover. To see how dramatic that is as a change in the law, pick up any copy of the Federal Rules of Civil Procedure and look at the draft complaints and answers, the models placed there by the Federal Rules Advisory Committee, every one of them would have to be dismissed under Ashcroft versus Iqbal is unduly conclusory. What does plausibility mean? This is what's being litigated in district courts and courts of appeals literally every day. Having read hundreds, if not thousands, of these lower court cases, it's clear to me what's plausible to one district judge isn't plausible to another. At the Court of Appeals level, what's plausible depends so much on the panel. But there is no doubt that this has had the effect of closing the courthouse door to many litigants. For example, studies have been done by the Federal Judicial Center, now law professors, that document a very significant increase in motions to dismiss being granted and a significant increase specifically with regard to civil rights cases. And so many more are filed, many more are granted, and this is particularly true with regard to civil rights litigation. What's striking here is nobody asked the Supreme Court to change the pleading standard. Certainly, people could have gone to the Federal Rules Commission to ask them to change the pleading standard, could have gone to Congress, could have documented to the court a problem that required it. But the court did this entirely on its own. And it's clear, I think, that it's a desire to protect defendants from litigation very much at the expense of plaintiffs. Let me pick a fourth and final area that I want to talk about where the Supreme Court has closed the courthouse door, and that's to criminal defendants. An example I want to talk about here concerns habeas corpus. If there's any area where the law has changed in the time that I've been a lawyer and a law professor, it's with regard to habeas corpus. Habeas corpus is often referred to as the Great Writ. It comes from England. It says that a person who's held in violation of the Constitution and laws of the United States can go to federal court for a remedy. But the Supreme Court and Congress and the Anti-Terrorism and Effective Death Penalty Act have closed the courthouse door so that individuals, even innocent individuals, have no access to a remedy. Let me use as my example here a case again from just a couple years ago, a case called Cullen versus Pinholster. Pinholster was convicted in Los Angeles of a triple murder. As soon as the jury came back with its verdict, the prosecutors, the assistant district attorney, said to the judge they wanted a penalty phase to be scheduled where the jury could decide whether to impose the death penalty. The defense lawyers objected. The prosecutors hadn't made the disclosures that are required under California law to have the death penalty sought. The judge overruled the defense objections and said he understood they hadn't had time to prepare. He would give them as much time as they wanted to get ready for the penalty phase. The defense lawyer said, oh, never mind, we're ready to go with the penalty phase now. And the judge scheduled to start 6 days later on the Monday. The defense offered only one witness at the penalty phase, the defendant's mother, and by all accounts, she wasn't an effective witness. Pinholster was sentenced to death. The California Supreme Court affirmed the conviction and the sentence. A habeas corpus petition was then filed for Pinholster. It argued ineffective assistance of counsel. There were declarations from the defense lawyers that they'd done literally no investigation to prepare for the penalty phase. Additionally, they had declarations from Pinholster's elementary school teachers and family members that had been seriously abused as a child. The Supreme Court has said those are mitigating factors for a jury to consider deciding to impose the death penalty. The defendants had declarations from doctors that Pinholster had serious mental illness. He was bipolar, he had a seizure disorder. Again, those are mitigating factors for a jury to consider. The district court then held an evidentiary hearing and found ineffective assistance of counsel. The Ninth Circuit, in an 8-3 en banc ruling, affirmed. The Supreme Court reversed an opinion by Justice Thomas. Justice Thomas said that federal courts on habeas corpus are not allowed to hold an evidentiary hearing. Federal courts are limited to the record from the state court. So the federal court erred here by letting the declarations come in, by holding the hearing where it found ineffective assistance of counsel. Now, Justice Sotomayor pointed to the fact that there's a statutory provision, 2254E2, that specifically authorizes evidentiary hearings. Even more important, she said, what if it's a situation where a person, after being convicted and after state appeals are exhausted, finds evidence showing that he or she is actually innocent, how then is that going to be brought forward? Or what if the defendant who finds evidence of a serious constitutional violation? What then is the defendant to do? Now, I think the majority's response was, well, the defendant can go to state court. But what if it's a state court that doesn't have post-conviction proceedings available? Or what if, like in California, it's just a postcard denial, even in a death penalty case, with no evidentiary hearing? In all of these instances, individuals, even innocent individuals, even those wrongly convicted, will have no remedy available. The court has truly slammed the courthouse door shut. So what I've tried to show you through these examples is a pattern. I think the whole is much greater than the parts. If you put together how the Supreme Court has closed the courthouse door with regard to suing business, suing the government, being a plaintiff, being a criminal defendant, you see a very troubling overall pattern. I think it's particularly insidious because it will never make headlines. When the Supreme Court hands down a decision restricting standing, that doesn't make the front page of the New York Times. If the Supreme Court said that the government can give unlimited aid to parochial schools, that's the headline. But if the court says no one has standing to sue the government giving aid to parochial schools, it has the same effect, but no one's going to pay attention. When Ashcroft versus Iqbal came down, I talked to a good friend of mine who was on the staff of the House Judiciary Committee. I said, Congress can cure this. Congress can pass a statute going back to the Conley versus Gibson pleading standard. And he said, you're not going to engage members of Congress in pleading standards. He said, unless you can bring in a lot of Lilly Ledbetters, you're not going to be able to get Congress to take this seriously. Lilly Ledbetter was the plaintiff in an employment discrimination suit who the Supreme Court ruled against. Then Congress passed a statute to overturn this. Why is this happening? Well, one explanation is that this is a pro-business court and that so many of the decisions can be explained this way. The decisions favoring arbitration over adjudication, the decisions restricting suits against generic drug companies, the decisions limiting pleading, what can be brought in federal court under Ashcroft versus Iqbal, all about being pro-business. But I think something larger than that is going on. Certainly restricting suits against the government, restricting habeas by criminal defendants isn't just about being pro-business. I worry that what's going on here is that the Supreme Court is losing faith in the adjudicatory process. A theme that runs through all of the cases that I've been talking about this afternoon is a court that really distrusts the judiciary. Think about the arbitration and the class action cases, where that's expressed explicitly by Justice Scalia, a case I talked about, and in other decisions. Think about what the court says when it's keeping people from being able to sue the government, not really trusting the courts to be able to provide the remedy. Certainly, the restrictions of pleading reflect a desire to keep matters out of court at the earliest stage, not trusting the trial courts to be able to manage litigation and exclude frivolous suits. The restrictions on habeas corpus are very much based on a view that criminal defendants were abusing the system, aided by liberal federal district court judges. And so I wonder, as the title of this talk posed, whether it's not all about the Supreme Court losing faith in the courts in the adjudicatory process. And if that's so, that might be the scariest things that I talked about. We all learned in junior high school civics that any person who's injured gets his or her day in court. What I'm suggesting to you this afternoon is that sadly, increasingly, that's a myth. Thank you. So my instructions would talk 45 minutes, and that would leave us 10 minutes for questions. Please.
Thank you very much for the talk. Thank you. I agree with basically everything. I think I understand.
Sure, and if you can.
I agree with basically everything you said.
Okay, you can stop there. No, go ahead. I'm sorry.
But your conclusion. I don't think your conclusion is big enough.
Okay.
In that it doesn't seem to me that there's a trend that's limited to the court itself. But if, in fact, we look at what goes on in terms of the executive branch and the legislature, there is a trend, right, this similar trend of foreclosing down both access to the courts, right, and if you don't have access to the courts, then at least hopefully you might depend upon regulators, but we can't depend upon regulators either, nor can we trust Congress, right, to, in fact, laws that are going to open up democracy. So it seems to me that you're really talking about something very fundamental about democracy and what we understand to be citizenship and rights. So I'd love to hear.
I don't disagree with that.
Stop there.
Fair enough. I wanted to make a more limited point of the court and what it's doing with regard to access to justice and what might explain it. But I think that there is a larger issue with regard to the Supreme Court's deference to Congress and the executive. And I think we could tie it to even a larger social phenomenon of people losing faith in their government. And at this moment in time, who can blame them? So, but again, it's not that I disagree with you, it's that I was trying to make a more limited point. And I guess I should explain a little bit of the context and then get to the next question. I've just finished the manuscript for a book titled The Case Against the Supreme Court. And this is actually a chapter from that, or part of 2 chapters from that book. And so that's the context of why I'm talking about the Supreme Court, and I'm talking about it in this context. And what I should also say is, for each of the things I talked about, I could give so many more examples, but just pick ones that would fit within the 45 minutes I had. Please.
You started this discussion with talking about the ideological split in the court, and I was curious if you know whether there's a historical precedent for that, because so much of the Supreme Court's legitimacy comes from this view that it's objective, and that ideological split can be bad. And so I was just curious if that has happened before, if that's something in our current system.
First, the court has been ideologically divided often through American history. Think about the Lochner decisions, the decisions that struck down the New Deal programs. The court was very ideologically divided. And we could come up with many more examples of courts that are ideologically divided. There's one thing that we've certainly never had in recent memory, and I don't know if we've ever had, and that's that the court's ideological division exactly parallels the political party of the presidents who appointed them. The 5 conservative justices, Roberts, Scalia, Kennedy, Thomas, and Alito, were all appointed by Republican presidents, and the 4 liberal justices, Ginsburg, Breyer, Sotomayor, and Kagan, were all appointed by Democratic presidents. We've certainly not had that in recent years. Stevens and Souter were in the liberal bloc, but they were appointed by Republican presidents. Byron White was a pretty conservative justice. He was one of the 2 dissenters in Roe. He dissents in Miranda versus Arizona. He was appointed by a Democratic president. So what you have that's different now, certainly in recent decades, is ideology so corresponding to the political party of the president, which I think then makes it even more seem political. The other that I have to say is, I don't believe that there's such a thing as objective constitutional law. I don't believe there's ever been such a thing as objective constitutional law. The Constitution is written in broad, open, textured language, and the court always has to give meaning to it. Think of Marbury versus Madison. The power of the courts to engage in judicial review isn't mentioned in the text of the Constitution. The court created it. They made a choice to do that. Decisions are always choices. But there is such a strong desire of people to believe that justices and judges are just umpires calling balls and strikes, even though we all, I think, believe that that's nonsense. Please.
So you mentioned a bunch of different antagonisms the court has. Are there sufficient cases by which we could rank those antagonisms in their minds, right? So do we have situations that are potentially pro-business but are anti-access to the courts, or pro-access to the courts, where we can see this group, the Kennedy group of the court, having to choose between its preferences to protect business on the one hand, and its preferences to close the courthouse doors on the other. And
Yes, and in some ways, I mean, obviously, American Express versus Italian Colors was business litigation. It's big business versus small business, and the court came down on the side of big business. Or you could take my pharmaceutical cases. In Wyeth versus Levine, the court comes down on the patient over the drug company. And then in Pliva versus Mincing and Mutual Pharmaceuticals for Bartlett for the drug companies over the patient. I alluded to, but without mentioning, there's a study that came out this year. It was done by Lee Epstein, who's now a professor at USC, Richard Posner from the Seventh Circuit, and William Landis at the University of Chicago, that comes up with a measure of whether courts are pro-business, and I think answers your question to some extent. And then they have all their statistics and their graphs in terms of assessing that. And you may want to look at their article for an answer to that. One area where I have looked at this is with regard to federalism decisions. As you know, during the Rehnquist era, one of the things that the Supreme Court was doing was reviving federalism as a limit on federal government power. The court limited the Commerce Clause, limited Congress' power under Section 5 of the 14th Amendment, revived the 10th Amendment as a limit, greatly expanded sovereign immunity. One would have thought that justices who are committed to states' rights would want to narrow the instance in which federal law preempts state law. One way of empowering states is to limit when they're being preempted. And yet, almost without exception, the Rehnquist court found preemption when there were business challenges to state and local regulations of business. In your answer of hierarchy, their commitment to being pro-business took precedence over their commitment to states' rights. In the First Amendment preemption area, Lorillard Tobacco versus Riley, Massachusetts imposed a limit on where there could be cigarette ads. And the Supreme Court, 5-4, ruled in favor of Lorillard, with the conservatives, O'Connor, Rehnquist, Kennedy, Scalia, Thomas, is the majority, Stevens, Souter, Ginsburg, and Breyer dissenting. Why I mention that, there you see the priority, pro-business getting priority over states' rights. And I can show you a lot of cases that fit that. Please.
Well, perhaps there's also a sociological component in that the court is imposed now as a court of elites. They all went to Harvard or Yale. Most of them were magnificent appellate litigators or appellate judges. So you could view this as one, they're protecting the elites too. Maybe this is just a hostility towards trial court judges, and I think only Justice Sotomayor sat as a trial court judge. And so perhaps it's, if this is an effort to protect from whence they have come.
And in the book that I alluded to, at least it's now a manuscript, I talk about explaining why the court has often failed, is that the justices are elites. And they're elites from a very narrow part of the country. Every borough but Staten Island has a justice who grew up there, but there's only 2 justices on the court who grew up west of the Mississippi, and only one who, when appointed, was from west of the Mississippi. And this isn't unique to this court. Throughout American history, the Supreme Court justices have been elites, though never before chosen from so few law schools as right now. I don't know that that explains why they're closing the courthouse doors. I don't know that that explains why necessarily they're pro-business. Somebody could be an elite and be liberal and favor regulation more. So I don't know is the answer to that. You do touch on something else that I think is important. This is a court with a remarkable lack of practical legal experience. To my knowledge, neither Justice Scalia nor Breyer, and I use them as examples because I'm ideologically neutral then, ever argued a case in any court before becoming Federal Court of Appeals justices. I know that Elena Kagan never argued a case in any court till as Solicitor General she argued Citizens United versus Federal Election Commission. Now, Sonia Sotomayor was an assistant district attorney. She was a federal district court judge and a Federal Court of Appeals judge. Samuel Alito was a prosecutor and the Federal Court of Appeals judge. But it's a court with a remarkable lack of experience at the trial level. And that may reflect some of its decisions that reflect a lack of understanding. I can give other examples of that as well. Time for one more question? Please. I can't hear you. I apologize.
On that last point, Chemerinsky, on practical experience of the court, would that explain why the
Great occasion to talk about something that's before the court now that could have enormous practical significance, and I'll try to do so really quickly. In 2011, the court decided a case called Stern v. Marshall. And if you heard about it, it's probably because it was about Anna Nicole Smith. She was referred to as Vicki Lynn Marshall in the litigation. And the issue before the Supreme Court, to make a very long story short, it's out of time, is whether or not a bankruptcy court could issue a final judgment over a state law claim. And the Supreme Court ruled 5-4 that a bankruptcy court can't issue a final judgment over a state law claim. Chief Justice Roberts wrote, joined by Scalia, Kennedy, Thomas, and Alito. Breyer wrote for the dissenters, joined by Ginsburg, Sotomayor, and Kagan. And the court said only an Article III judge with life tenure can issue a final judgment over a state law claim. Bankruptcy judges are appointed for 14-year terms. They can't do so. Well, on many levels, this doesn't make much sense. Who usually issues final judgments over state law claims? State court judges. And generally, they don't have life tenure. Also, why did the court split ideologically 5-4 on this issue? Well, I think it reflects a deeper theme in constitutional law. The conservatives tend to be much more formalistic, believing that they can find answers and reason from them, and the liberals tend to be much more functional, as Justice Breyer was here. Well, as soon as Stern v. Marshall came down, I said, and said many occasions, I said it in print, I said it to bankruptcy judges, that the key is going to be whether consent can cure this problem. If consent can cure the problem, it's no big deal that bankruptcy judges can get consent in most instances. But if consent can't cure the problem, it's going to dramatically change the nature of federal district courts. The day after the case came down, a bankruptcy judge in Houston by the name of Marvin Isger called me and said, I issue 9,000 orders a year. And he said 25% of them have a state law claim. Does that mean in all of those instances I've just got to send it to the district court for a final judgment? But even more, magistrate judges issue final judgments, including holding jury trials with consent of the parties. If a bankruptcy judge can't do this with consent, then magistrate judges can't. And what about federal statutes that require arbitration? Arbiters don't have life tenure. Does all of this now have to go to federal district court? The Supreme Court has before it this term a case called Executive Benefits versus Arkeson, and the Ninth Circuit was called In re Bellingham Insurance, on the issue of whether consent is sufficient. And there's a split among the circuits. The Seventh Circuit here in August, in Wellness International versus Sharif, said that consent is not sufficient. You can't cure a structural problem by consent. The Sixth Circuit in Stone v. Waldman last October came to the conclusion, whereas the Ninth Circuit came the opposite way. Now, what's the Supreme Court going to do? Well, this goes directly to your question. Do the justices begin to understand what it will mean if they say that consent is not sufficient in terms of bankruptcy litigation, magistrate judges, arbitration, the workload of the federal district courts, when almost none of them have ever practiced or been judges in that court? The case will be argued in January. Thank you so much.